All right, so your job in this discussion assignment is to familiarize yourself with the debate about constitutional interpretation, to take a position on it, and then comment upon one of the other students' postings about this. In these slides, I'm going to, and there are just 3 here, I'm going to summarize the 2 positions, originalism and living constitution, and provide you with some of the issues in which this debate becomes very pronounced. So first, let's talk about originalism. This is the view that's associated quite often with Antonin Scalia, who recently passed away, and Clarence Thomas, who's currently on the court. And the idea is that when you're trying to decide what some passage of the Constitution means, the answer to the question is that it means what it meant when it was written. The practices and views that were acceptable when the words were written or added to the Constitution are the answers to the question about what is acceptable now, or what the Constitution requires or protects now. And so, for instance, the example that's in your textbook and Scalia likes to bring up quite often is the issue of the death penalty. So when you're interpreting what does cruel and unusual punishment mean, which is the phrase that you find in the 8th Amendment to the Constitution, well, that amendment was added to the Constitution in 1791, and so you look and see, well, what was considered cruel and unusual in 1791, and if some mode of punishment was acceptable then it's certainly not prohibited by the Constitution today. So, for example, in the 18th century, it was acceptable to put someone to death for stealing a horse. Now, Scalia has said many times, I'm not advocating having the death penalty for someone who steals a horse, but he's just saying that the Constitution doesn't prohibit that. And if one doesn't like those practices or views, then by all means pass laws or amend the Constitution to make those things illegal or unconstitutional. And Scalia will say, for instance, that on the issue of using that kind of a punishment for stealing a horse, the system's worked pretty well. We have no place in the country where that's an acceptable punishment, and so the legislative process has worked very well. People have decided that they don't want to do that, but his point is that the Constitution does not prevent it. It's not a constitutional question. He also argues that consequences cannot guide judges' decisions about these things. So you can't ask judges to come up with different answers to the questions because one doesn't like what happens when you apply the original meaning. So in other words, you can't ask judges, say, well, I don't like the idea of putting someone to death for killing a horse, so I'm going to ask a judge to tell us that we can't do it. In his view, and he said this many times, the job of constitutional interpretation is easy. He calls it a piece of cake. You just need to find out what was acceptable in the 18th century, and then that's your answer. And he argues this is what the framers intended. Now, sorry. Okay, one more thing. Okay, so the other view, living constitution. Stephen Breyer on the court right now is one of the most vocal articulators of this position. He argues that the document sets up a system that includes principles and a process for solving our own problems that the writers of the Constitution couldn't have imagined. And it was not meant to give us answers to specific questions about what practices are acceptable. That's what laws do, not constitutions. He argues that the fact that they made it so hard to amend the Constitution, that if you follow the originalist view of things, then what you're simply doing is privileging the practices and views of the 18th century over today's practices and views. And there's no particular reason to do that. He also argues that consequences really do matter. One has to look to the consequences to see if one likes them before deciding how to interpret the Constitution a certain way. But with one very important caveat, and that is that they must always still be interpreted in a way to uphold constitutional principles. He argues, for example, that justices aren't bound to give a less good answer simply because some argue that that is what was acceptable when the Constitution was written. But they also can't give an answer based solely on consequences and ignore the principle that's at stake. So in other words, when it comes to the cruel and unusual punishment value, it's not required of a judge to say, well, it's not a constitutional question whether you execute someone for stealing a horse. That would be considered today a less good position. That would be unacceptable today. And no, we're not required to simply look beyond that. Breyer says that the job of constitutional interpretation is really hard. He says if it was just a question of looking to 18th century practices, then why not just put historians on the court? That it's actually pretty hard and requires careful judgment. And he argues this is what the framers intended. They never would have wanted us to bind ourselves to the practices and views of the 18th century.